Hello and welcome to a LOLhsc Legal Studies paid video. Now today we're going to be going through the international crime section. I will seem like I'm rushing some parts because there is quite a bit of content to get through, but I'll really try my best to cover everything I can. And yeah, alright, so pretty much the first dot point is define international crime. Now there's two categories of international crime which you need to know about. The first one is transnational crime, which takes place initially within one country, but which have international law consequences. This includes stuff like drug importation to different countries, as we've seen with Chappelle Corby and the Bali Nine and all that. So that's pretty much transnational crime. There's also other stuff like sex slavery, illegal arms trade, and people trafficking. And then the second category is crimes against the international community. Now these are crimes that disrupt the operation, peace and security of the international community. Now this includes crimes against humanity, war crimes, genocide and crimes of aggression. Now if you don't know what crimes of aggression are, this is a relatively new law. They are the planning, preparation, initiation or execution by a person in a position effectively to exercise control over or to direct the political or military action of state. Now if you're unsure about that, just Google it and you'll find that. Otherwise it's in the notes attached with the file. Now move on to describe the international measures used to deal with international crime. Now the first thing is extradition. Now extradition, it doesn't matter how you say it, but you've probably heard of this in Australia. It's outlined under the Extradition Act 1988 Commonwealth. It pretty much means it's the process of legal surrender of a fugitive to the jurisdiction of another state, country or government for trial. Now you'll hear the term like fleeing the country. It means like if there is no extradition agreement between two countries, effectively just stay in the country without being arrested, because really there's no reason for the local police force to arrest them. Now the second measure is the International Criminal Court. Now this is one of the major measures. It's where offenders can be tried under the Rome Statute for committing crimes against the international community. Now the Rome Statute was a UN declaration which nations then had to agree to, and in Australia's case, as we are a dualist system, don't know what that is, look in the human rights videos, pretty much means that for any UN conventions to be into our legislation, they have to be reflected in our own legislation, which is enacted by the Parliament. So in our case it was the International Criminal Court Act 2002, and then there's the consequential amendments, which is the most recent one. Now it has been relatively effective. It isn't very expensive, so it hasn't prosecuted as many cases probably as liked, but a recent one you can talk about is Thomas Dillo in 2012 for 14 years. Just for the numbers, there's 15 cases and in 7 situations have been brought before the HSC, and that was actually the first conviction of Thomas Dillo. Now the third, sorry about the coughing, the third measure used to deal with international crime is ad hoc tribunals. This is a very important one. Now pretty much they're tribunals which are held, which convict people of mainly war crimes, and there's so many examples of this. There's Arusha Tribunal, which had 62 convictions in 72 cases. That was hearing the Rwanda genocide. Then we had the Special Court for Sierra Leone, in which Charles Taylor, Google him if you must, was sentenced to 50 years. This is all about genocide. Yeah, so then there's also been the International Criminal Tribunal for the former Yugoslavia, in which there was 161 indictments and 64 convictions. That was a major one. Now the fourth way in which the international crime can be dealt with is domestic legislation. Now one of the major problems with international crime, international criminal law pretty much, or international law, is that there really is limitations due to jurisdictional boundaries, which pretty much means that because each country has their own state sovereignty and their own right to govern their own nation and have their own laws, there really is a limited amount of in which one country can affect another country, or what the UN can do. And this was recognized in the 2011 Crime Commission Annual Report, which stated that transnational networked criminal enterprises pose a jurisdictional and logistical challenge to law enforcement and regulatory agencies and present different but equally important challenges to lawmakers and policy agencies. The best defense against transnational crime is multinational and multi-agency investigations designed to disrupt the international networks at key hubs where trafficking routes intersect and may be vulnerable. Now, the people who will enforce this is stuff like the Australian Federal Police, which was established under the Australian Federal Police Act 1979 Commonwealth, and furthermore the Australian Crime Commission, which is established under the Australian Crime Commission Act 2002. Pretty much it provides legal reinforcement to defuse this organised crime within Australia. Now, people say, well, why can't they just deal with it individually? Really, there is such a necessity for cooperation because it's only effective when it's a whole group. This is evident in the Virtual Global Task Force, which is like 9 international child protection enforcement agencies. One operation they ran was called Operation Rescue, which targeted offenders in a global child abuse ring, and we saw 184 offenders arrested. See, and these organizations like this are supported by the UN Convention Against Transnational Organized Crime, which is just provided there in the slide. The way it impacts Australian laws, we've seen cases now where there has been convictions, and that's evident in R.V. Wee Tang 2009, who was sentenced to 10 years for slavery, E.V. Dobby 2008, who was sentenced to 5 years, R.V. McIver and Tanichit 2012, who was sentenced to 12 and 11 years, and the extradition of Jargan Vasilivkovich, hard name to say, to Croatia for war crimes. Now, there is more legislation which has international law links, and that's the Crimes Act 1914 Commonwealth, which makes it illegal for Australian citizens to engage in sexual activity with a child under the age of 16. That's not as relevant, but it still shows how it's implemented into our domestic legislation. We now move into the final area, which effectiveness, in which Stephen Freeland, he's an international law expert from Australia. He suggests 3 criteria to show how effective is the international law legal system and domestic legal system in dealing with international crime. Now, criteria 1 is, has our international legal system stopped or reduced the number of wars? Well, it's really not going to be able to stop these wars or crimes, but just punish the people who commit them. Really, like, international law is not as good as dealing with current conflicts, because most of them are internal, and this again, as I mentioned before, provides issues with state sovereignty and about how anything internal, there's very fine balance between having state sovereignty and imposing on state sovereignty. So it's about having that accountability, pretty much. Really, there is no way for international law to stop non-state actors such as terrorist groups, which really is what causes a lot of the wars, the terrorist groups fighting against the government. There is really no way for international law to stop that. Now, so criteria 2, it kind of fails criteria 1, but it fails and succeeds in it. And criteria 2, have there been a lot of prosecutions? Less than 200 people prosecuted by the ad hoc tribunals and ICC, with the first 3 just now on. There was only 1 in 2012. And compare it to the cost, by 2015 there would have been $6.3 billion US spent globally on these international courts and tribunals. They're really only ever been designed to prosecute those most responsible for crimes against humanity, and they weren't really meant to replace domestic courts. What it does, however, is create precedents for future leaders. So, as I said before, it's prosecution. It's not really how many has there been. There has been quite a few, considering these are all major crimes, as I said. So it's not really about the number. It's about that they're holding the leaders accountable, and it's really providing justice for those affected by major crimes such as Rwanda genocide, as mentioned before. Now, criteria 3 is, are international criminals more accountable? So it really builds up to this. The first 2 you talk about how it builds up accountability, and yes, heads of state used to consider themselves above the law. However, this is no longer the case. With leaders such as Saddam Hussein, Charles Taylor, and Slobodan they're now aware that they're going to be held accountable for any crimes against humanity, even if it is within their own borders. And if you go back 15 years, this was not thinkable. A lot of the stuff in other countries were just, they used to say it's in their country, they have to deal with it, but it's not that. That's not the thought process nowadays. The only problem is that there is a reliance that is placed on the political will of world leaders to hold international criminals responsible for what they have done in the domestic legal system, which again can be a bit iffy because of the state sovereignty. You don't want to impact too much. What makes them accountable is stuff like the Rome Statute that is then implemented in legislation in Australia. This makes it binding. Any UN convention is not binding, but having it in your domestic legislation is binding and really provides that accountability, because there is no ifs and buts. If they do it, it's against the law. Yeah, so just to summarize quickly, there's two types of international crime: transnational, such as sex slavery, and crimes against the international community, such as genocide. Then we have different measures. We have extradition, International Criminal Court, ad hoc tribunal with domestic legislation, which is saying stuff like the virtual global task force being organised. And then, is it effective? It's expensive, yes, but it is overall making leaders more accountable for their actions. Means that there is no longer the idea that you're in your own state, do whatever you want. There is, even though it happens after the crime, it's making them know that they're going to get caught if they do it, and they're going to get punished. So I hope this helped. Just have a look at the notes, go over. I spoke through a lot of the notes. Just relate it back, and thanks for purchasing LOLhsc paid videos.